prevent dowry debt, to stop dowry harassment, and to make the home secure for women. That forum was the magistrate court. It is the same magistrate's court that we are now dealing with DP. So DP forum and 498 forum is one and the same. Now if you see the domestic 498 provisions, there are two explanations here. When a woman is subjected to cruelty, so the Act itself has two provisions of cruelty specified there. One said, explanation A said, if a woman is harassed for dowry and other people are harassed, then you can file under this Act. The second being, if any harm is caused to the woman, life, limb or sanity, any kind of harassment that is caused to her, and then no word of dowry over there. So now we have two different kinds of cruelty coming up. What did the women's movement want at that point of time? It was presumed that if you take a very stringent action against the perpetrators of the violence, that is husband and his family, then violence will stop. So immediate arrest, non-conformability, and provision being very stringent. This was what we had asked for 498, what we got also in 498. 20 years down, as we go along, 1983 now, to nearly 25 years later, we have Domestic Violence Act. Now, Domestic Violence Act places violence in a totally different scheme, in a totally different category than 498A. But 498A is a criminal one for punishment, and domestic violence is a civil one for protection. Now, we have protection and prevention going along in the same code. But meanwhile, if we see really the history of 498A, somehow the courts have begun to view every woman who files under 498A with suspicion. There's so much of media hype that this is misused. Women are exploiting the system, women are misusing the system and getting husband and his entire family arrested. If you see the judgments on 498A, mostly where the conviction takes place is where the woman has died. When 302 murder is not applied, when 304B dowry debt is not applied, when 306 abetment to suicide is not applied, and it comes down to 498A where maximum punishment is 3 years. Usually they get 6 months. Despite this, the myth of misuse happens. Now let us look at a woman who negotiates this right. She goes to the police station, files the complaint. Now we all know from our experience that most women who file the cases are not interested in breaking the marriage. The women are interested in a certain kind of negotiation with the husband and his family to protect their rights. Before they come to the court, before they come to us, they also explore other mechanisms of family, community, local panchayats, etc. to resolve that particular problem. The problem being husband's alcoholism, husband beating, harassment, dowry-related harassment, other harassment, general terms, husband having an affair, a whole lot of series of discomfort, of crimes that are being perpetrated to her. She wants to solve this. And when she wants to solve it, there is no other measure except for the lady. She go to the police station as a final resort. She will file this complaint, hoping that the police will mediate, hoping that police will call the husband, lock him up for 2 or 3 days, and some sense will prevail, and then he comes out, and then the marriage can be saved. Unfortunately, 498 is non-conformable. Once you enter the system, you cannot retract. If you want to retract, you have to go to the High Court. High Courts are also very strict about it. Sometimes 498 gets used as a negotiation for divorce settlement. If I 498, the husband will come for settling. All of us as lawyers, we know the purpose for which 498 gets used, and seldom is the punishment clause is what the woman aspires for, that he will be punished and he will be locked up for 3 years. Most of the time it becomes a negotiating settlement. This is 498. When you look at, in the same court, we look at DV. Now here you see a lot of negotiations, a scope for negotiations, a scope for settlement, a scope for counseling. CRPC, who looks at 498A and who looks at DV. The same moment if it comes under DV, within 60 days you will give an order, okay, protection order also, or residence order, but there is no avenue of implementation. You find under 498A, the woman becomes a suspect, and the woman doesn't have the possibility of retraction. My concern here, because time is running short, this is one issue. When one new act comes in, we tend to forget older provisions and older acts. But as long as we are using 125 CRPC, we are using the Guardians and Wards Act custody, we are using CPC and protection injunction and for residents, which was there prior to DV, we have a whole lot of remedies at our disposal. We also have the newer remedies at our disposal. How do we place them? How do you place them so that negotiation is also there, seriousness is also there, somewhere in reconciliation of these terms, where we look at 498, not only is dowry related, when the offense is when the crime is serious, when the beating is severe, then how do you use 498? If you don't want to use 498, how we use DV? And I think when we say protection officers, etc., even under 498, there were supposed to be protection officers, dowry prevention commission officers, all the commissions are supposed to be there. This is nothing new. But because this has become a human agenda to prevent crimes, now there is greater focus on these all other machineries. My concern here is that how do you bring the criminal provisions, the civil provisions in the magistrate court, as well as how do we link to family laws? I don't have space to go into family laws, but all of you know family laws, and how do you negotiate in the district court, how do you negotiate in the family court for women's rights? So I think we have to bring all these different avenues together in order to protect women beyond the immediate provisions of the Act. Thank you.
I would now like to call upon Senior Advocate Kirti Singh from Women's Legal Forum, who will be the moderator for the coming session. Advocate Kirti Singh. Our next session is on state-wise. We have state-wise presentations coming up now, and that is on sharing of court experience and judgments. So I call up upon Ms. Hafisa Mugupkar from Kashmir.
Good morning to everybody, and greetings from Jammu and Kashmir. I welcome all of you to that wonderful state, visit and see how beautiful it is. In our state, we have our own constitution, and the Domestic Violence Act, it has come in the center. It's a 2005, everybody knows that, and it came into existence, started implementation during 2006. But before I talk about that, I just want to take you to your childhood, rather my childhood, where we all women are here assembled. If I talk about my own childhood, when I was young, we were 3 sisters, and I'm the third one. There was, my brother was then to born, and there was not much jubilation at my place that we didn't have a brother. And when we came to know that shortly we are going to have brother, there was jubilation. And after, some months, my mother, she gave birth to a son. There was jubilation, festival, everybody was so happy. Even we were also very jubilant that we were going to have a brother. And my mother was she was so happy that she felt that she is going to, my girls are going to have a brother, and he will protect them. There's a protection from their brother. So this is the story of, I think, in every household that we just say that there should be a brother, and women are ignorant. We are not sometimes assertive to tell what we are and what we want basically. Assertiveness is very important. I think so that women, but we agree that not to be assertive and say, okay, whatever we are given, we just say okay. And by the time, we grew, and my mother used to tell me that, you have to, my mother, she is a very great woman, and I learned so many things. Everyone learns from others, and I also learn from her. But, excuse me, whenever she, okay.
announce now, I'm really sorry for that everyone has to keep up the timing. All the panelists have 10 minutes to go, and also concentrate more on your own sharings of the judgments.
Okay. Since we don't have the Domestic Violence Act, I want to share some, because coalition is here, so I want to tell some experiences to them. So when I was there, and my mother used to tell me how, we are the rice eaters, and when we eat rice, sometimes we get, at the bottom, everybody has seen the rice get, sometimes very hard. And my mother used to tell me, just eat that, because we will have a lot of hair. I would always say, I was really a rebel, and I would tell them, no, give it to your son so that he will have no stages and will grow, immediately and will be our protector. Anyway, so this is the story. Everybody has seen that, and we are not protecting ourselves. Women all the time we are at helm affairs, and all the time we are asking for the laws. There are so many laws. There are already so many laws, and at the initial stage, people are very happy that we have the law. Women are very happy we have that, but nobody is going to, use that law. Absolutely not. They are not, especially women living in the rural areas. They are not going to. They are not basically aware of the law. Domestic Violence Act, when it came, so Government of Jammu and Kashmir also thought that we must also have this act with us. Since I told you we have our own constitution, and we couldn't extend this act to our state. And later on, government thought, when we were pressing her, I just want to give you an introduction which I didn't give you. I'm from administration of Jammu and Kashmir, and I'm a member secretary of the state government.